see the students now?
Yes, ma'am. Now they are visible.
Okay. Now, they will inform you by showing their phones when your time left only 5 minutes. Got it?
Okay, ma'am.
Yeah. With the permission of learned judges, we shall commence the proceeding preliminary round of second international moot court competition. Now, first team is A1 team will go first to present their case. Yeah,
Sorry.
you can start, beta, with the
Ma'am, just
permission
a
of
question.
judges.
We are not informed that we have got the petitioner side or the respondent side. And where is the sitting?
Beta, in the preliminary round, uh, you have to present their case from both the sides, and you have only 15 minutes, as the rules are in the brochure, right? And in the quarter final round, we will draw a lots. At that time, you will be maybe you have the chance to present the case on the behalf of prosecution or maybe on the behalf of the defense, right? But in preliminary round, you have to present the case within 15 minutes from both sides. Any doubts?
Ma'am, we have separate 15 minutes for the appellant side, or we have to
No,
conclude both the
no.
sides in
See,
15 minutes.
total 15 minutes from both the sides you have.
Okay,
You
ma'am.
have gone through the brochure. In the
Yes,
brochure, it
ma'am.
is written already that you have only 15 minutes for presentation of the case
Okay, ma'am.
for both of you. Got it? Yeah,
Okay,
you can
ma'am.
start.
Okay. May it please this Honorable Supreme Court of Indonesia. This is counsel appearing on the behalf of appellant in the case Vicky versus State of Andhra Pradesh. If your ladyship permits, may I state the fact of the case in hand?
Sure, please proceed. Am I audible to you?
Much, yes, ma'am.
I request the council to please proceed with their case.
Okay. Much obliged. Vicky, a 17-year-old student at Harvard University, possesses a mysterious charm that wants Miss Eliza towards him, create a bond that seems to be unbreakable. On 14 January, Eliza received some explicit or wild images of herself on the social media account on Hacker. Eliza's parents decide to approach the court and file a criminal complaint at Mani's police station of Andhra Pradesh state. Cyber cell, on tracking the IP address, get to know that this device belongs to Mr. Vicky's sister. But tech expert Winnie later on declared that the appellant system was hacked and the account and the created account belongs to the hacking fake account, and Wiki is not liable for creating those malicious images, as these images were created by the AI account, AI content, and rest of the information was taken from the Aliza social media account. Incident was reported to the High Court of authorities as Mr. Vicky was made an accused for the crime. They both were considered as good friends and having each other's back, and they both were thriving in their education. But in the last August, Miss Eliza had received an offer of undergraduate studies from Stephens University situated abroad, where Mr. Vicky has also applied, but he is disqualified. And for the said offer, there is it leads to a disagreement because Mr. Vicky had applied for the same but did not get the offer. Still, they are well wisher, and on the during the investigation, witness one, Sayana, a friend of Aliza, said that that Aliza may have staged these clashes as she did such activity in the past as well. On the 24th January, Dr. Anish, who is witness to, said that Vicky is a thoughtful person and he is mature enough that he will not do something like that. On 24 January, Mr. Vinny also analyzes during the digital trail and identify the hacking attempts on Wiki's social media account, which leads to the which leads that the hacker got all his personal information and allowing himself sending the messages through his accounts and also to get the credentials also. And this is done through the phishing app. On January 26th, Winnie informed the AI content was generated and used to create those malicious images, and rest of the information had gained to Miss Aliza's personal data through her social media interactions. If your lordships is well versed with the facts, may I proceed on to the issues, your lordship?
Sir,
Much obliged.
please, um, please seek the permission with the another judge also. Sir,
Yes,
Yes, no,
yes, ma'am.
please.
I have asked if your lordship is well versed with the facts. May I proceed on to the issues, your lordship?
Continue, please. Continue.
please continue.
Okay, much obliged. Your lordship, the issue in the present case are as follows. Issue 1. Whether the Mr. Vicky can be held liable for the cybercrime and the harassment endured by Aliza. If your lordship is satisfied with this contention, may I move on to the next contention? Issue 2 deals whether the age of Mr. Vicky warrants special consideration for him and should he be regarded as the juvenile or an adult in these legal proceedings. Issue 3 deals with whether the penalty imposed on Mr. Vicky is justified and legitimate. And issue 4 deals with whether the Wiki's fundamental right of privacy has been breached in the investigation as his system was looked into without his permission and knowledge,
Uh,
whether the investigation
just
should
a
be
minute.
set.
Just a minute. You repeat that issue of penalty. What you said?
Whether the penalty imposed on Mr. Vicky is justified or legitimate.
Okay.
That's issue number 3, sir.
Yes, sir. This is the issue number 3. And the
Sir, this
issue
is
no,
on the
issue.
last page of the MOOT proposition. Issues
Sorry.
are mentioned. I think the issues are mentioned on the last page of the MOOT proposition.
Okay. Ma'am, I will be dealing with the first two issues in 7.5 minutes, and my co-counsel will be arguing the third and the fourth issue in 7.5 minutes, reserving 5 minutes for rebuttal as the instruction. Your Lordship, may I proceed with the first issue?
Yes,
Your
Yes.
Lordship, may
sir.
I proceed with the first issue? Much
Yes, please,
obliged.
please, please, please.
It is humbly submitted that the Supreme Court of Indonesia that the charges against the appellant are completely unjustified as noted by the third witness. During the course of investigation, described the digital trail that exposed attempts to hack the appellant's social media account. According to the charges, that the Section 66B of the Information Technology Act 2000, that the punishment for sending offensive message through services etc. is not justified as it is also held in the case United States versus Drew 2009, in which the court held that the accused had not done a crime of serious nature due to hacking of his system and lack of the clear laws addressing to the specific.
Your voice is eating. मतलब प्रॉब्लम आ रही है यहाँ पर.
Am I
आपकी
not
आवाज बहुत
audible?
इको. I request the technical department to please look into it.
Sorry, ma'am.
The point is voice. There is echo in the voice. I think
There is,
uh, this is not only one speaker problem. It is voice of I think every speaker is echoing.
hmm.
Probably mine also may be echoing.
मैम आवाज
Yes.
में थोड़ी प्रॉब्लम आ रही है, साउंड प्रॉब्लम हो रही है, आवाज गूंज रही है।
नाउ ऑडिबल है मैम सर आपकी यहाँ पे आवाज आ रही है इट्स ऑडिबल प्रॉपर्ली
मैम स्टूडेंट्स पार्टिसिपेंट्स की नहीं आ रही, पार्टिसिपेंट्स की गूंज रही
Just participant, please see whether two persons have logged in at the same point. Just
है।
see if two persons have logged in there itself, then there may be issue of echoing.
No, sir, only one device has been working.
But still your voice is echoing. Are you
Maybe.
using the voice of your laptop?
Yes, sir.
You please try your headphone once. Well, let us see.
Okay, sir. Just a minute. Sorry for the inconvenience.
Okay, now it is not echoing. Now it is not echoing.
Okay, sir.
Uh, So there was, I think, more than one person probably logged in at one place. That's why this echoing was happening. Now you continue. Let us see what happens.
It is also held in the case United States versus Drew 2009, mentioned in the page 17. In this case, the accused is charges with the hacking and the cyberbullying and harassment. But the court held that due to the hacking of his account, he is not directly liable for the charges. So the court mentioned that the accused had not done a crime of very serious nature due to the hacking of his system and lack of clear laws addressing the specific section involved. Now referring to the section 66 of the IT Act 2000, punishment for identified theft. It is also mentioned in the case State versus Nix 2011, referred to the page 11, that accused is not responsible for this cyber stalking and harassment due to because of the accused is also a victim of cyber stalking, because his system was hacked and the court held that he or she is not be liable for the permission. Okay. May I, if your lordship is satisfied with the first issue, may I move on to the next issue?
So your argument is over for the first issue.
Yes, sir.
So you say that Mr. Vicky, what is your how you summarize on the first argument? What is your conclusive statement on the first argument? What you have concluded?
Sir, your lordship, that Mr. Vicky has not done a cyberbullying and a harassment because his system was hacked, according to the statement of cyber cell and the statement of witness 3. That his system was hacked and all his personal information gained by the hacker and access his all personal social media account.
The subordinate court and the High Court convicted
Yes,
Vicky by imposing 10 years sentence.
yes, ma'am.
And as per your contention, Vicky is not an accused.
Yes, ma'am.
Vicky
Vicky.
is also a victim in terms because his system was hacked, and
Yes,
he's a victim on the hands of hackers.
yes, ma'am.
So, will you please explain the sentence which has been imposed by the state, by the subordinate and the High Court? Because there is a story or there is a background of Vicky and Aliza.
Yes, ma'am.
Specifically, Vicky's system got hacked and the malicious or explicit pictures or messages has been sent to Alicia only.
No, ma'am. They
And
are sent
moreover,
to
Vicky
Aliza
and
as well.
Alicia have some background, some kind of a ego, which because he couldn't get the admission, he was disqualified for the I think for the international or the abroad institution. So doesn't it sound weird that the two person having the background story and on the same transaction, the accused system got hacked and the same girl received the explicit messages from Vicky's account. I really
Okay,
want
ma'am.
to draw your attention towards the background, madam. Will you please
Okay, ma'am.
explain on that?
Yes, ma'am.
Because
It's not.
this is the continuity. Moreover, it is the transaction, the same transaction.
Okay, ma'am. I
This is a
totally agree.
transaction of the multiple transactions. Will you please throw some light on
Yes,
it?
Your Lordships, I totally agree with this point, but it is not only about Aliza who got the explicit images. As per the witness 4, Kartikeya, who stated that not only Aliza, some of the friends of Vicky also get some unsolicited text. And if somebody's
Do
account
they
was
have their
hacked,
statement on
according to
record?
the cyber,
The other witnesses or the other people who received the explicit messages from the, as per you, the hacked account of Vicky, do they have the statement on record? Do they
sorry, ma'am.
appear before the court? Are they
No,
in the list of witnesses from Vicky's side?
no, ma'am. As Aliza also stated in the January, Aliza has also mentioned during the investigation that there are some images which contain some special information which was Vicky was privy about. But when the account of those details were asked, she was failed to mention those specific details, which leads to that Mr. Vicky was privy about, and these information refers or belongs to a specific person. As the tech expert says that this information has been taken from social media interaction of the respondent.
So, according to you, Vicky has no role to play in harassing or threatening or defaming the woman.
Ma'am, according to the cyber cell, it is clearly mentioned that the IP address which belongs to Mr. Vicky, but
Hmm.
there are so many hacking attempts, and these attempts are done through the phishing attack which leads that somebody got the personal information or credentials or the so many details of your credit banks, credit accounts, credit cards. So it will leads to that he gain the access through which he can send messages through the account of Mr. Vicky to different people.
Do you have any document on record which shows or states that the Vicky's account was hacked?
Sorry, ma'am.
Do you have any document on record which clearly state that the Vicky's account was hacked? Did
Ma'am, it is
IT issued any report that shows that this account was hacked?
Ma'am, during investigation, it is clearly mentioned that cyber cell statement and the statement of the witness 3, who is a tech expert, which explains about that the Mr. Vicky's account was hacked. And there are so many hacking attempts through a phishing attempt through which the hacker gain all his personal information and access to his social media account, through which he can directly send messages to the people on behalf of Mr. Vicky, as he is not even trying to figure out that what is happening with his accounts. It is clearly
When did
mentioned in the
Vicky come to
statement.
when did Vicky come to know that his account was hacked?
Ma'am, when the cyber cell get to know that through the expertise of Miss Winnie, who is witness 3.
Uh, could the investigating team during the investigation of the case reach to uh, the claimed third party who breached the Wiki's account? Could they be traced?
Hmm.
Okay,
Sir,
much obliged, sir.
I am asking same thing.
It is mentioned on 24 January that tech expert Vinny analyzed the digital trail, identify the hacking attempts on Mr. Vicky's social media account, and also explain the hacker gained his access.
24th of January, as per us in the mood problem, 24th of January, it's about Dr. Anish statement.
Sorry, ma'am.
24th of January,
Yes, ma'am.
Dr. Anish was summoned by the inspector. I think there is some confusion regarding to the date. You have right said it on 24th of January.
Just a minute.
Huh.
Ma'am, it is clearly mentioned in the sub point, in the eighth point of the investigation timeline, January 24,
Yeah.
that in the fifth line that Mr. Sharma seeks the expertise of witness 3, tech expert Vinny. Vinny analyzed the digital trail and identify hacking attempts on on Vicky's social media account. And later on, she explained that Vicky's account was compromised through a phishing attack. The hacker gained all his personal information and allowing them to send those messages. And on 26th January, Vinny elaborated that AI generated content was used to create those malicious images, and they had access to Aliza's personal data through her social media interaction. In case of both hacking, it is a case of both hacking and privacy invasion.
Okay.
Yes.
So, whether your argument for the first issue is over?
Hmm.
Yes, sir.
Okay. So, what should be your ideal argument for this when there is sufficient doubt that there is no certainty who the actual perpetrators of this incident is? What should be the your actual argument? Have you completed your IPC and CRPC in your academics?
No, sir. No, sir. We are from first year students. So
First year student. Okay. Chalo, let us proceed to next.
okay, sir. So my second issue deals with whether the age of Mr. Vicky warrants a special consideration for him, and should he be regarded as a juvenile or an adult in these legal proceedings. So, according to the age of Mr. Vicky,
Hmm.
that he is a 17-year-old student at Howard High School. So, for to there is a special need that Mr. Vicky warrants a special consideration for him as he is a juvenile according to his age in these legal proceedings. So I would like that there is a proper, and the High Court and the subordinate court considered him as an adult, as they are on the specifying that he is adult or he is mature enough for his act and about their consequences. But according to the Juvenile Justice Act 2020, 2015, there is a proper preliminary inquiry written in the section 15 that any juvenile that should be treated as an adult must be go through with the preliminary inquiry that examines his mental and physical capacity, that he should be treated as a juvenile or an adult. So it is not done, and it is also that the Mr. Vicky's career is also did get damaged due to the 10 years imprisonment. And there is also written in section 33 about the heinous crime of the Juvenile Justice Act 2015, that if there is a punishment of 7 years or more than that, there should be a proper preliminary inquiry, which stated that the juvenile is mature enough for considering him as an adult. And also, it is written that that the section 63 of the in Juvenile Justice Act also speaks about that if there is the involvement of a juvenile in a particular case, there should be a proper police units always consider which always considering the juveniles, as their training has been also done according to the welfare and the cases related in the involvement of juveniles. So these are some facts which is not done by the High Court for considering him as an adult. And also, a minor cannot held liable for the phishing act through the AI generated content, as his account was already hacked, and he is not liable for the harassment and cyberbullying endured by Eliza. It is also lead to hamper his career and future as well, as he is a student in the in the high school, and he has no past no past criminal records. So he should not be liable to treated him as an adult in these legal proceedings, as cyberbullying is not a heinous crime for treating him as an adult.
So how do you counter the expert opinion in para 6 on January 23 timeline? The expert clearly mentioned, Dr. Anish clearly mentioned that he was very mature for his age. So he is mature enough beyond his age. How do you counter this?
Sir, but
So
there
the
should
point which I am trying to make is, I want argument from your side that the expert which were hired by the police, whose help was taken by the police, he is of the opinion that his maturity is more than his age. So he is already 17 years. So maturity is of more than his age. So how do you counter that?
much obliged, sir. Your
Uh,
Lordship, it is clearly mentioned that this is that witness two is a school teacher of the Howard High School. He's not appointed by the police officers for the further inquiry, as they went to the school for gain their additional information which related to the appellant and the respondent. And it is also mentioned in the Kartikeya statement, who is the witness for that Vicky will not do any kind of this. Vicky will not harm any person. And Dr. Anish is also mentioned that he is a thoughtful person. He is not do something like that.
don't you think a thoughtful person, as Dr. Ali said or mentioned in his statement, Vicky is a thoughtful person. Vicky is a person who has a मतलब शॉर्ट टेम्पर पर्सन है, एक थॉटफुल पर्सन है और एक मेच्योर पर्सन भी है जो इस तरह का काम नहीं कर सकता, पर ये इतना सारा अकाउंट चला सकते हैं वेबसाइट एक एक प्रोफाइल मैनेज कर सकते हैं, सोशल मीडिया पे अपना अकाउंट मैनेज कर सकते हैं। ये भी तो हो सकता है कि वो अपना अकाउंट किसी से हैक भी करवा सकते हैं। He is a
Ma'am, but
mature enough person. He's a thoughtful person, and he wants to harm the lady. So he involves a third party in this matter. So he will have a clean set of his character or of his act.
lordship, that they were friends at the school, and they being the schoolmates as well.
सर आवाज इको हो रही है, I think, है ना? बच्चों
Voice
आपकी
is
आवाज
echoing. Technical team, please look into it. Voice is echoing.
I request the
And there
sound
are
manager.
so many.
मैम आवाज गूंज रही है बच्चों की।
सर हम मैम हमारी साइड से तो ओके है। स्टूडेंट्स बेटा यू प्लीज चेक फ्रॉम योर साइड।
नहीं नहीं, अभी अभी every speaker's voice is getting echoed. This you will have to see. Maybe we need to log in again, log out, log in again. Maybe, probably.
Hmm.
Am I audible?
Yes. Now you're on.
Okay. Your lordships, as your lordships, they were friends and the schoolmate, and being good friends, there are so many chances that one used to argue with another friend. Therefore, it does not mean that it will lead to merely such kind of such kind of harsh activity or action against that one should take in on the behalf on the
But
argument
being a
that or a
thoughtful person, he can do this. A thoughtful person means a person with multiple thoughts in his mind, a person with sound mind as well. So he can take this action against the lady. आपने मुझे बताया, डॉक्टर अनीस ने ये बोला, और मोर ओवर उन्हें शॉर्ट टाइम पर, वो एक गुस्से वाले इंसान है, तो क्या पता गुस्से में आके रिवेंजफुल होके उन्होंने लेडी को हार्म करने के लिए एक थॉट दिया, बीइंग अ थॉटफुल पर्सन, कि मैं थर्ड पार्टी हैकर को इन्वॉल्व करता हूँ और लेडी को परेशान करता हूँ।
lordship
उनकी
if
बात
they
पे कभी चीज क्लियर ही ना हो कि उन्होंने कुछ गलत करा है, स्टिल सबऑर्डिनेट कोर्ट और हाई कोर्ट ने उन्हें 10 साल की जेल दी है।
okay
Apart from that, sorry, apart from that, being the age of 17 years, he was considered as adult, because being a thoughtful person, being a sound mind person, being a person of 17 years, court do not consider him as a juvenile. He was punished as an adult because he already knew about the consequences of his act. This is clearly
much obliged. But ma'am, I would like to mention that the witness second also mentioned that Vicky was very calm about the argument, and he is agree to apply in any other university situated abroad. But Aliza was very bitter about the quarrel, and and witness one Saina also stated that maybe the quarrel was started by Aliza, as she has done such kind of disagreement or arguments in the past events as well. And according to the psychological reports, short tempered people are very quick reactive, that they cannot wait for 6 months of planning to do such kind of act. If they are having some short tempered, they will burst out at that time only. And if the appellant waited for 6 months, he can wait also that Miss Aliza went to abroad, and there is lack of facilities that she can go through if she face this kind of harassment or cyberbullying, that she can went to the police station or can sue or file a complaint complaint against the uh, perpetrator.
but it may also be happen that he took 6 months to plan about his way to threaten the lady.
Yes,
The
ma'am.
theory, according to me, that for 6 months he planned the entire event, and he planned in such a way that he will not be responsible for any kind of a act or for any kind of a criminal act. And finally he made it executed by the third party. तो 6 महीने मुझे लगता है कि विकी ने प्लान किया,
Your
and
lordship,
planning and execution, and come out with a clean sheet. ये
your
मैं
lordship, if Vicky has planned for 6 months to do such kind of harsh act against the respondent, he will not use his IP address to send those images. If
ये
he is
यही तो होता है
dealing
कि
with the
that might be something he missed by chance.
But ma'am, according to the psychological reports, that the short-tempered people are very quick reactive, that they will not wait for such a long period of time. And if he plans, if he is a thoughtful person, according to Dr. Anish, or he is a mature person, according to witness too, so he is mature enough, or he is clever enough not to do such kind of lenient mistake, that he is using his IP address to send those malicious images to the respondent.
Sir,
I am okay with the argument submitted. Next, you
this
can proceed to next point, next issue.
next two issues I
So
think.
much obliged. Your lordships, may I left the podium for my co-counsel to dealing with the next two issues.
Yeah, continue.
Much obliged, sir.
Your
How
Lordship,
much
if
time
I
do they have? I think 7.5 minutes to the one counsel, to the one meter, and 7.5 minutes to the other.
other
For
one,
the
yes, ma'am.
respondent side, I think, right? You are for the respondent side.
From a,
Can you clarify,
no,
you are from the respondent
no,
side
ma'am.
or
No, ma'am.
You are appellant or
Your Lordship,
respondent?
yes, Your Lordship, I'm from the appellant side for the issue 3 and 4.
okay?
Okay.
Your Lordship, if I may continue from my co-counsel left, from where my co-counsel left.
Yes, yes.
Yeah. Your Lordship, I would be dealing with the issue 3 and 4 of the same case. Issue 3, whether the penalty imposed on the Mr. Vicky is justified and legitimate. And it's about no penalty because act was done by the AI and by the phishing act as per the stated by the witness 3 and the section 2 subclause 12 of the juvenile care and protection act 2015 also clear that the child who has not completed the 18 year, he is also a minor one as explained in the act named as juvenile justice care and protection act for children act 2015. A child who has not completed 18 years is considered as a child in a juvenile justice care and protection for children act 2015. Also a thoughtful person too as stated by a doctor. As per findings and account, he seems to so innocent, not done any heinous crime under Juvenile Justice Act of 2015. Also, a heinous offence is stated in the section 2 subclause 33 as include punishment for which the minimum punishment under IPC or any law for the time being is forced in imprisonment for the 7 year. And also we also consider the validity of the evidence as we saw in the case whole case merely based on the presumptions as accusatory of an individual needs contains significant weight of the evidence in the absence of undivisible evidence. The reputation of the reputation of Mr. Vicky is also damaged by this act of Eliza, and the respondent. This also included the section 499 of the IPC state about the defamation. Case Sikandar Mehato versus Tunna 2014 also clear about that the juvenility of the accused must be established with the valid evidences. So it is a must oblige thing that the validity of the evidence are must in every case, as this case is totally based on the presumptions as stated uh, in the case, and my also by my co-counsel also. And the second case is about the Kedarnath Kashyap versus State of Chhattisgarh 2018. Also states that during investigation found that aspects photos of the complainant were found in the mobile and Kedarnath and Jamnabal hard disk of and also a hard disk of computer of other one applicant. None of the witness had stated that Kedarnath had shown, transmitted, or published those wild photos to anyone. Since the offense of the spread picture was not established, the applicant was acquitted. Also mentioned in the same case about the Vicky scenario and about the Nirbhaya case. Also, this case not only led to the legal challenges allowing stricter sentence for juvenile in the certain cases, but it also served as a reminder of complicities involved in ensuring both justice for the victims and a change for rehabilitation for minor who enter into a criminal justice system. According to this, juveniles should be treated differently and should give the chance to reform themselves as in the through the process of rehabilitation, not by the process of punishment. So, juvenile has also a right to change ourselves by this. As per findings, he finds solution. He finds solution as per stated by the witness three, Winnie. As per, if your lordship satisfied with the issue 3, may I move on to the issue number 4? If your lordship,
The earlier speaker emphasized that he's not guilty.
yes, yes, your lordship,
And you are trying to emphasize that he should be treated as juvenile.
Mhm.
yes, means about actually I am dealing with
You
the
want
issue
you
number
want
3 and
basically
4.
you want him to be punished as juvenile.
No, sir, actually I am by the case
Because
of
you
Nirbhaya.
clearly mentioned it that as per section 2 subclause 33 of the IPC,
Yes,
the punishment for the heinous crime
yes,
is I think
yes.
7 years. So according to you, he should be punished some to the 7 years or about 7 years. So you yourself considering him as an adult, not as a juvenile.
No, actually I am stating about that by this
Sir,
section
am I right,
that
sir?
no, your lordship. Actually, by this act, I want to state you that it include the punishment for the 7 years. Means as he is not considered in the juvenile section or a juvenile juvenile by the lower courts and high courts, but he should be treated as a juvenile because according to Nirbhaya case, as stated by a renowned judgment, according to this, juvenile should be treated differently and should give a chance to reform themselves. And it is also a renowned case in which it is clearly mentioned
See,
about
what
the
I want
juvenile.
to clarify from you is whether you think that he needs reform. What is your argument actually? Conclusive argument. Your partner
Yes, sir.
on the issue number 1 and 2 has said that he is not guilty.
So actually, by the yes, actually by this, I want to say you that no, matlab actually the issue is that there should be no matlab uh, about the
आराम से कोई नहीं कोई नहीं.
Mr.
Don't confuse. Query is very simple. Based on your own argument, your partner has claimed that he is not guilty. You say that he should be treated as juvenile while deciding the punishment.
Yes, sir.
Absolutely.
Yes.
Whether
Yes, you're
you want to say that again, that while punishing him, he should be treated as juvenile. You want to say that?
yes, sir. Yes, your lordship.
Or
Okay.
you
He
are
should be.
seeking the relief of acquittal. Or you are seeking the relief for acquittal.
Ma'am, actually, I am dealing with the issue 3 and issue 4 from the side of appellant. Same side. Actually, my co-counsel dealing with the issue number 1 and 2 for from the side of appellant, and I am taking the issue number
Any
3 and 4 from
okay,
the
okay.
side of
You
appellant
in which year you are LLB?
First
in
year, I
first
think.
year.
First year. Okay, no issue. Have you read IPC CRPC evidence? No.
No, no, must not.
Sir, during research, but not as a
Otherwise, don't.
particular.
Okay, okay,
Yes,
okay.
yes,
So
your
you
lordship.
both are a team, no? One team.
Actually, we three are in our team.
Mother
You
We
three
mooted
four are
are.
one,
Okay.
mooted
medical,
two, the researcher.
and yes,
Okay.
You
So
other mooted two.
yes,
Jyoti
yes,
ma'am,
sir.
where is the court master? I think Jyoti ma'am. Ma'am, where is the court master?
Yes, ma'am.
Ma'am, where is the court master? Time पता लगेगा.
Ma'am, time is already over because you are asking the questions from the
okay, okay.
student. That's
ठीक है.
why the
That
time
that
is
that.
extended.
हाँ ठीक है ठीक है.
That is
चलो. You
But nice.
have you concluded? Have you concluded issue number 3?
Yes, your lordship.
Okay.
I
Continue
just
on with
want
we
to
issue.
clear
proceed
that.
to the issue number 4 and wind up. Issue number 4, please. Sir, issue number 4,
Yeah. Yes. Yes.
Much
please.
obliged, your lordship. Okay. Issue number 4, which state about that. Whether Vicky's fundamental right of privacy has been breached in the investigation, as his system was logged in
So,
without his permission and knowledge, whether the investigation should be set aside on the aforesaid ground. So issue number 4, yes, it has been breached right of the privacy, as it is one of the important fundamental right of a person according to the Constitution of India, which included as a Constitution of Indonesia in this case, and we can't access the social media account of any user without the proper decorum and approvals. Aliza's parents use the power in the wrong way. As we say that when police unauthorized the information from the computer system of the wiki to extract the information for social media accounts, as per the article 21 of the constitution, article 21 of the Indian constitution states about the protection of the life and liberty, and no person shall be deprived of the life and the personal liberty except according to the procedure established by the law. Article 21, as laid down in the Menka Gandhi versus Union of India case also, it must be just, fair and reasonable or equitable, not illusionary, means to take away this fundamental right even of an as accused there must be a law rectified by the parliament. And in India there is currently no law according to court to force any accused person to reveal password or any information from their phone, and demanding information from them is against the law. Article 20, subclause C also states that no person accused of any offense shall be compelled to be as a witness against himself. It also works as a protective umbrella against the testimonials, and right to privacy recognized as a fundamental in India. In a case of Puttaswamy versus Union of
oh,
India, the Chief Justice J.S. Keir reversed previous ruling that derived privacy of the constitutional protection, and the code recognized privacy as inherent to live a life with personal liberty, and guarantees a life of a person with liberty. And also a renowned case which states about that the R. Rajagopal versus state of Tamil Nadu. This means you have control over your personal information, publishing private details without consent, even if true or complementary violates this rights. IT Acts also prohibit this type of activity. Anyone who illegally capture or illegally take any such information from the system, he she should be treated according to the law, and install viruses and prevents other from the access the system can be fined up with the charges also. And according to the case of people's union for the civil liberties versus Union of India, it also stated that the people have right to hold private conversation on the phone without any
Okay,
interference of the public authority also.
concluded.
Yes, your lordship, much obliged. Your
Okay, thank you.
Hmm.
Well done.
Well done. But
thank
all the
you. Much
best
obliged. Thank
for
you.
the future. Thank you. Thank you so much. Jyoti ma'am, can we leave or what? We have to do?
Yes, ma'am. We can start with the second team now, na?
Yes,
We have
yes,
next
yes,
team also.
yes.
Hmm.
But you can leave. I'll intimate you further things.
Okay, ma'am. Thank
Okay.
you so
A nice
much.
presentation.
इसी को भिजवा दो.
Second team, team B1, turn on your cameras. Yes. Now, second team B1 is representing their case. You have only 15 minutes from both sides to present your case. Right? Yeah, you can start.
ज्योति मैम प्लीज कोर्ट मास्टर को बोलेगा कि टाइम दिखाए क्योंकि हमें खुद नहीं पता चलता है टाइम का.
मैम टाइम शो किया था एक्चुअली वो टाइम ओवर होता गया.
चला.
हम अभी
Sorry.
अभी शो करते हैं.
Good morning, ma'am. Good morning, sir. I am speaker number 2 and I'm waiting for my speaker number 1. Oh, counselor.
So advocate is reaching late in the court.
Sir, I'm really very sorry. He's already joined. He has already joined. I don't know why he's like being late. Just give me a few minutes and I'll ask him.
What you are seeking now? What is this called? You are seeking a relief from the court. Do you know what this is called?
Hmm.
Sorry,
In
sir.
which year? In which year you are?
Sir, in third year.
Okay, this is called passover. You check your partner whether he is joined or not.
Or maybe an adverse order on your way.
So counsel number 1 is messaging that he is present, but whether we will be able to hear his audio.
Yes, sir. Yes, sir.
So tell him to speak. Counsel number 1. We are getting his message, but no, team B1 is saying, who is team B1?
Team B1 is here only. You are team B1, right?
Yes.
I think team B1 must be a respondent.
So,
Team B1, there are two screens we are actually sharing.
okay. So we are not getting his audio, neither video.
Maybe I can just turn my off and he can turn his on.
So he is messaged. It is glitch on the part of management.
Sir,
ज्योति जी आप देखिए.
speaker 2 can start with the submission.
Sir, I'm checking. Better tell me where is your other speaker?
He has already joined in. He's there in this meeting.
There must be some technical glitch.
At present, not there, na?
No, he's already there. He has already joined.
If what if there is, then turn on the camera. Speaker, are you speaker 1?
Speaker number 2.
Speaker 2.
Where is speaker number 1?
he has already joined and he's unable to just turn on his camera and mic.
Sir, can we?
He is joining, I think.
Yeah, just wait a second. Yeah, turn on your camera. D1 team. Speaker one. Turn on your camera, beta.
Speaker 1, we are receiving your messages, sir. Please turn on the camera.
Sir, they are joining again.
कोई नहीं होता है, VC में होता है, चलेगा.
लॉग इन लॉगआउट कर रहे हैं.
हाँ जी, हाँ जी.
हाँ, नो प्रॉब्लम. हमने तो लॉग इन कर ही रखा है.
हाँ, टाइम ज्यादा हो रहा है. एक्चुअली हमारा ना लंच के बाद क्वार्टर फाइनल राउंड है,
तो लंच कितने बजे? 1:30 बजे.
आगे स्पीकर
हाँ.
या बोथ आर देयर.
Am I
Yes,
audible?
sir.
Am I audible?
Yes, yes, yes.
Yes, you are.
Good afternoon, my lords. The council is here in the matter of Mr.
Your volume is little low. Either you get your mic very close or you may use headphone, whichever is feasible for you.
Yes.
Or increase the
My
volume.
lordship, the council is here in the matter of Mr. Vicky versus State of Andhra Pradesh, appearing on the behalf of the respondent. May I address the bench as lordships?
Yes, yes.
Your choice, open to you.
हाँ.
Much
Your choice.
with if the court is well versed with the facts of the case, may I directly proceed with the arguments?
Yes, yes, you start.
Thank you, Your Lordship.
Your volume is little low, you will have to increase it.
My lordship, the first issue is whether whether Mr. Vicky can be held liable for the cyberbullying and harassment endured by Eliza. My lordship, it is contended that the statement given on the 24th of January by one of the fan states that there was a motive, that there is a possibility of the motive that Mr. Vicky can do such an act. And my lordship, I will cite one of the case law
Will you
of
please
the
mention the para number, sir? 24th of January, or the point number, what it may be called. Are you reading
My-
from the investigation timeline?
ma'am, I am reading on the memorial.
Acha, ma'am.
Okay, okay.
Yes, ma'am. On the 8th page, it's on the January 20. Oh, sorry, ma'am. It's January 17th. Please, sorry, ignore my say.
No problem.
The statement of the witness one, Saina, that she recalls the past arguments between Eliza and Vicky, suggesting a possible motive for the incident. She also informed that Miss Eliza may have staged the quarrel as she do it before. Furthermore, in this addition to this judgment, I will add the fact of January 23 statement of the Dr. Anish. He said that the Vicky is mature enough that he knows the consequences of the offense. My lordship, I will cite the case law of the Sonelal versus State of UP, where the Honorable Supreme Court held that motive may be inferred from the past enmity. In the present case, there was certain quarrels between the hit and heated arguments between Mr. Vicky and Miss Eliza. In pursuance of those facts, the Mr. Vicky has committed such an offense. My lordship, secondly, the appellant has taken a ground that IP address can't be traced. My lordship, the fundamental basic principle of the networking is that each particular device has certain IP address which can't be hacked or spoofed. So there is no possibility that the device was hacked. It was either the possibility that the accused Mr. Vicky has given the access to the third party or he himself do such an act. My Lordship, the evidence in this present case, there is no as such direct evidence, but the court has to be rely on the circumstantial evidences. My Lordship, the right of the Miss Eliza has been violated by the act of the Mr. Vicky accused by sending her the malicious expertise photos. It is humbly contended that the individuals are prohibiting from the creating, selling, renting, distributing, circulating, or mailing any material such as book, pamphlet, paper slides, films, writings, drawing, painting, photographs. This all has been cited in the case law of the in the section number 4 of the Indecent Women Representation Act. My Lordship, in this present case, the modesty of the woman was uh,
I request
attacked.
the council, sorry, but I request the council to please read point 4, January 18, where he said that he asserts I would never do something like that to Aliza. My accounts were compromised and I have
Ma'am,
been trying to figure it out. Once they have resolved the dispute
ma'am, it is just a
and they have,
presumption. Ma'am, it is just a presumption. We can't take it as an direct evidence. The presumption is not based on the law, so we can't take a presumption. It
hmm,
needs to be justified with a reasonable
So,
validity.
on the same point, let us take your argument. Let us travel through your argument. You say that there was a quarrel between them,
hmm,
and
Yes, my lordship.
when they have already settled, so whether your
hmm.
argument that quarrel is the reason for this act is not presumption.
My lordship, but at the end, it was the Mr. Vicky who has blocked Miss Eliza on the social media platforms. So, although the dispute was resolved, but it can't be deemed to be resolved because
No,
it was the
only
Miss.
every possibility there. Only argument is you say that it is presumption that he has resolved the issue. Why your argument cannot be treated as merely presumption when you don't have any direct evidence? Do you have
My
any
lordship,
answer to that?
yes, my lordship. My lordship, Miss Eliza has
Moreover,
told.
the act of this hacking or sending the explicit, I think the messages, the malicious messages, were sent to the lady after 6 months of the quarrel. Will
My
you
lordship,
please throw some light on this? The matter was settled. They have compromised their accounts. After the heated argument, they decide not to talk to each other. Still, after 6 months of the quarrel, if we raise the presumption or we raise the presumption before the court, so after the presumption of not being into this, he acted after 6 months, his account was hacked and everything took place.
my lordship, for this purpose, I will go for the para number 12 of the memorial, where the Honorable Supreme Court had held that it is the legal frameworks recognize the court's competence to presume the occurrence of certain facts when they are deemed likely in the context of common natural phenomena, human behavior, and public and private business as they pertain to the details of the particular case. Yes, my lordship. I feel that I have answered.
Sir, I don't have the memory on my table.
Uh, my lordship, in the case uh, of
Only
Raju
7 minutes
Panduranga,
are left.
my lordship, in the case of Raju Panduranga Mahale versus State of Maharashtra, the Honorable Supreme Court has held the legal framework recognizes the court's competence to presume the occurrence of certain facts when they are deemed likely in the context of common natural phenomena, human behavior, and public and private business as they pertain to the details of the particular case. My lords, in the same case, in this case, the acts of the Miss Eliza, she at the end blocked and she wasn't interested to talk with Mr. Vicky, but It was the Mr. Wiki who has blocked him, and through the IP spoofing, the tech expert has identified that the photos which were viral are from the account of the Mr. Wiki itself. And because the Mr. Wiki has already blocked, but for the purpose of deepfaking the photos, he must have unblocked her and tried to contact her indirectly.
Okay,
Because without an
this is your argument on point number one,
yes, my lordship.
or you want to add anything else?
Uh, that's all, my lordship. My lordship, I just want to add on one point that the intention and knowledge are not necessary to be proved because it is a course of mind, and the same was held in the state of Punjab versus Major Singh case. So the prosecution has no burden to prove the intention or the motive of the accused here.
In this case,
Yes, my lordship.
so that
It's my
that judgment applies to all criminal offense or only on in respect to this case?
My lordship, it is considered in this particular case the female late child was being sexually abused, so it will be applied to this particular case also. Although the Supreme Court judgments are binding on all the judgments, on the all the courts.
So you say that the burden of proof lies on the accused. So that is what
No,
you
no,
want
my
to say?
lordship. My lordship, I want to just to say that it is not the burden on the prosecution to prove the intention or the motive, because it is whatever the preparation is done in the mind. So it is impossible to prove the intention without the direct evidences.
Okay.
My lordship, may I proceed with the issue two?
Yeah. Proceed.
Please.
My lordship, the issue number two is whether the age of Mr. Vicky warrants special consideration for him or should be regarded as a juvenile or an adult in the
Only
court.
5 minutes left.
How
My
much time
lordship,
is
for
left
this,
now?
Ma'am, 5 minutes only.
ma'am,
Thank you.
I should rely on the on the figures given by the National Crime Record Bureau. According to their information, in the year 2012, 27,936 childs were in the conflict of the law, which
Hmm.
were increased by 500% from the year 2002 to 2015. The
Hmm.
IIT, the cyber crimes which are using through the AI technology needs to be
Hmm.
reformed. I suggest the honorable court with the judgment of the one particular case that the relevant provisions of the Juvenile Justice Act of Section 2, subsection
Hmm.
12 and 13 must be interpreted to mean
Hmm.
that juvenile who are intellectually, emotionally,
Hmm.
and mentally mature enough to understand the implication of their actions and who have
Hmm.
committed serious offenses are not
But if
subject to
his
the proof.
account was hacked, sir, how he come to know about the implication of his or the consequences? I
My lordship,
understand the person is mature enough to take care of his things, but a person who does not have the knowledge about the hacking of his own account, so how he will be responsible for the harassing the lady?
My lordship, there is the fundamental of the networking that IP address can't be hacked. So the police has
Hmm.
identified the accused from the IP address, not from the account, social media account.
Hmm.
So he knows the consequences of the act he is committing in the
Maybe his
present.
account, his computer or his system was used by somebody else. कोई थर्ड
Uh,
पर्सन आया उसने हैक कर लिया अकाउंट और आईपी
my lord,
एड्रेस एक्यूज का ही कर दिया
but my lordship,
because
as
a
per the
juvenile you because being a juvenile it is not possible for a juvenile to such understanding or the level of maturity can be expected from a juvenile अगर accused होता ही तो आईपी एड्रेस भी चेंज करता अपना
my
he
lord
must
for
have used another place to hack the account or do something.
My lordship, for the purpose of this particular question, I refer to the statement of the witness to Dr. Anish, who is the mental health counselor. He stated that he is mature enough to know. So he is. We can consider that he is the maturity level he has attained. So he know the consequences of the act in the present scenario. The children of 17 to 18 years have much matured, developed brain that they know much more about the information, ITs and cyber laws.
So according to you, first he hacked his own account. He became the hacker himself. And
My
then he
lordship,
hacked the account of the lady. And through the hacked in such a way he made the circle and sent the malicious or the explicit images or the messages to the lady.
my lordship,
Is
as
this
per
your
the state, my lordship, may allow, I may argue.
hmm.
My
Yeah,
What
yeah,
lordship,
is
please.
the statement of witness number three, that is the Winnie Tech expert, says that during that purpose, the account was compromised. But the again question lies that although the account was hacked, but the IP address can't be hacked. So the concepts, these are the two different concepts of the IP address and the social media. The photos may be morphed by the hacking, but what the act from where the device the act has been done belongs to Mr. Wiki, and IP address that particular device can't be hacked.
Okay, so let us come to your argument on the juvenile status of the accused. So you want to
Uh,
say that he should not be treated as juvenile, and he should be treated as adult only. And for
yes,
that, you are on which case laws you are relying on?
my lordship, I will rely on the one of the book where it is the bad juveniles and the worst juveniles. It is an according to this, according to the psychological and behavior.
What is this? What is this bad juvenile, good juvenile? What is this? This is book.
Yes, my lordship,
Okay,
it's the
so it is
title.
written by whom? Whether he is an expert in this field?
My lordship, actually, he is the one of the jurists, well-known
He is the
lawyers.
jurist. So are you submitting the content of this book as an evidence or expert opinion? In which form you are submitting it?
My lordship, I am submitting it as an expert opinion
So you are
that the
submitting
law.
as an opinion only, na?
Yes, my lordship.
Okay. So you already have an opinion on record during the investigation. So the opinion on which you are relying, Dr. Anish opinion, you have relied that he is very mature for his age, but at the same time, Dr. Anish also says that Vicky was calm and decided to apply for other political studies. Means he was not having any grudges at the time when your expert examined him. So on
Yes, my
which
lordship.
portion can you rely on partial opinion and disregard the partial opinion? Do you have any case law on this?
My lordship,
So do you have any supporting case law on this that if there is an opinion of an expert, you can rely on a part and you can disregard the other part? Do you have any case law? You are not audible. You are not audible.
my lordship, I didn't
Yes.
remember the case law, case citation, but I'll, as per the one of the case of the Supreme Court has held that wherever there are the direct or indirect evidences are available in the particular case, the opinion of the expert will not be have such a value as compared to the evidences.
Okay. So okay, fine, taken. Good point. So do you have any direct evidence
My lordship, in
from
this
this memo?
present case, we are having the circumstantial evidences only.
So you don't have the direct evidence. So you
Yes,
have to rely on expert opinion, isn't it? Even
but
for
my lordship,
considering the circumstantial evidence.
yes, my lordship, the circumstantial evidences directly attacks on the Mr. Vicky. So I contend that the circumstantial evidences must be considered in the present case.
Okay.
And
Fine,
my
very
lordship,
nice. Anything else you want to add?
nothing.
Good, good, good. So the second advocate may start her argument. You will start on point number three, issue number three.
Issue number 3 and issue number 4.
Okay, please continue.
Counsel for the respondent seeks permission to address the issue number 3 and 4.
Granted. Continue, please.
Thank you, Your Lordship. Issue number 3 talks about whether the penalty imposed on Mr. Vicky was justified and legitimate or not. It is humbly submitted that since the accused had been found guilty of different offences listed under the provisions, he is to be convicted and in consonance with the provisions of consecutive sentence read with the section 31 of CRPC in 1973. The concern is a question of law and not a question of fact. That is, whether on the basis of the facts and materials produced before the court, the sentence imposed on the accused on legitimate or not. It is humbly submitted that Honorable Court, Honorable High Court cannot reappreciate the evidences and facts in cases where it does not happen to be a court of first appeal. Additionally, that the High Court could not give its own decision on the facts and conclusion, for that the inferior court or tribunal. Furthermore, the Honorable Supreme Court stated that truthfulness, sufficiency, and acceptability of the material produced can only be done at the stage of trial.
Okay, so tell me one thing, just a small clarification. If any lower court has examined the facts contrary to the prescribed law, then whether the Supreme Court can look into it or not.
According to my knowledge, Your Lordship, the Supreme Court can give the permission and ask the lower courts to look into the matter once again.
Again, okay. Very right. Continue.
In the case of Navneet Mattal and versus Arjun Chetty, it was said that the High Court, even assuming that another view is possible on a reappreciation of the same evidence, that should not have been done by the High Court itself, as it cannot be taken as a first view appellate. It was based on no material. In the case of state of Jammu Kashmir and Shubham Sangra, 2022, Supreme Court held that in the criminal appeal of the Honorable Supreme Court, the alarmingly high incidence of adolescent delinquency in India needs to be addressed right away because of the way that teenagers have committed heinous and horrific crimes throughout the history and will likely to continue to do so. It is a question whether 2015 Juvenile Justice Care and Protection Act, Protection for Children Act serves its intended goal. That it is necessary to develop the sense that leniency with which minors are treated in the same manner should be named as the name of reformation and emboldening them to commit horrible crimes.
So one more question I would like to answer from you. Whether the determination of juvenility under the provisions of Juvenile Justice Act, whether this is a question of law or question of fact?
Question of law, Your Lordship.
So now whether this court can examine this, whether it was rightly determined or not.
Yes, Your Lordship.
Okay, continue.
I conclude this issue with saying that it is humbly submitted that the punishment imposed on Mr. Vicky is legitimate and justified in the eyes of law, that Mr. Vicky was well enough mature to understand the consequences of his acts done in order to take revenge from Miss Eliza. And therefore, there can be no defense established whatsoever. The circumstantial evidence and the investigation brought on the record points towards Mr. Vicky and states that he was well enough mature of his age and understood the consequences. The Honorable Court was well enough in its jurisdiction to pass such an order. Since Mr. Vicky has committed more than a single offense, it attracts the provisions of consecutive sentences, which has been rightly applied by the court. The offences committed by Mr. Vicky is grave offense, and that the punishment for the same should be harsh.
Okay. Point taken. So next point.
If judges are well versed with the issue 3, may I move to the issue number 4?
Yes. We have taken your point on issue 3. You are summarizing that he should not be treated as juvenile and the punishment is sufficient enough. That is your summary.
Yes, sir.
Okay.
The issue number 4 talks about whether the wiki's fundamental right of privacy has been breached in the investigation as the system was looked without his permission and knowledge, and whether the investigation should be set aside on the aforesaid ground or not. It is humbly submitted that before the court, the right of privacy should not be used as a shield for accused, because even if investigation against accused come under the right to privacy, and if examining the data for police investigation come under the right to privacy, then it will be too difficult for a person to prove that he is guilty in certain case. There is nothing in Article 21 of the Constitution of India and or any other articles that prohibits police from searching either person accused or his premises in the manner laid down by the court, nor the powers of the magistrate to issue a search warrant in the circumstances set out in the court abrogated by the Constitution. If there is a conflict between the right to fundamental rights, the right to privacy, and then the right that furthers public morality or public interest would be enforced. Since no fundamental right in our constitution is absolute, in the event of conflict between two fundamental rights, that is, right to privacy and right to fair trial, both of which arise under the expenses of Article 21. The right to privacy may have to be yield to the right of fair trial, although today privacy is recognized as a fundamental right. That would not alone make an evidence collected in the breach of that right inadmissible. The settled rule, purely from the standpoint of the law of evidence, is that the evidence is admissible as long as it relevant and regardless of how it has been collected. The right to fair trial is also considered as a fundamental right under Article 21. And according to this recent case, it was clearly mentioned first priority given to fair trial and provide fair trial respondent access appellant's data without his consent, because there was number of cases related to the destruction of evidence.
Okay. So have you concluded?
Just in few minutes.
Ah.
In the case of Magaraj Patodia versus R.K. Birla, it was held that the documents which was produced by improper or even illegal means could not bar its admissibility, provided its relevance and genuineness was proved. Article 21 not only ensures protection of life and personal liberty, but also a fair procedure.
Okay.
By concluding this issue, I say that it is humbly and most respectfully submitted that a right of privacy is not an absolute right, so Wiki cannot claim for the same in the investigation conducted. As the system was already been hacked through phishing attacks and had malware, so no reasonable expectation of privacy can be considered in this case, as it will be analogous to considering privacy in a house with no walls. And with this third-party doctrine comes into play that diminishes Wiki's claim of right to privacy. The court in various cases considers the evidence rather than the conduct of investigation.
So do you admit that his PC was already hacked and malware was there? Do you admit
Yes.
that? Okay.
His PC was already hacked, as the tech expert says. But
And malware was there.
Pardon your lordship.
And malware was already there.
Malware was already there, and his system was already compromised. So taking the grant of right to privacy should not be admissible in the court of law.
Concluded?
Prayer.
Yeah. Continue.
Wherefore, in the light of legal precedents and principles cited, considering the provisions of the statutes applied and arguments advanced, it is humbly pleaded before the Honorable Court that this court adjudges and declares that first, dismiss the appeal since it is devoid of merit. Second, uphold the order of the Honorable High Court and Subordinate Magistrate Court. Third, convict the accused under the section 509 and 354C of Indian Penal Code 1860 and read with Section 31 of Code of Criminal Procedure 1973 for the offences of sexual harassment, outraging the modesty of women with the intent to get revenge. Courts admit the recoveries and evidences made as a result of the testimonies credible and reliable, and or pass any such order or issue such directions or grants relief that it may deem fit in light of justice, equity, and good conscience.
Thank you. Thank you.
Thank you, thank you. Good job, guys.
Thank you, ma'am.
Only thing is advice for you because you are in third year now.
Third year of BLLB.
So there are certain things in the practice. Uh, there are two arts. One art of presenting what is in your favor. Other is the art of concealing what is not in your favor. So you have to learn both the arts. Okay. So your art of presenting was good. So there is some work needs to be done on art of concealing what is not in your favor. Okay. Thank you.
Thank you so much.
Thank you, team. Now, B2 will present their case. B2 is joining. Yeah, already joined.
Continue. Start. Who will speak first?
B2, you have only 15 minutes to present their case and 5 minutes for rebuttal and show rebuttal. So you have to conclude within 5 minutes, right? Your time will start.
Yeah, for the appellant side, B2.
Ma'am, we are asked that we need to represent both the sides.
Okay. So who will be from the appellant and who will be from the respondent?
Respondent.
Sir, we'll together represent both the sides.
One by one, na?
Yes, sir.
Who is mooter one?
The
And
issues
who is going
consecutively.
to present the appellant side?
Ma'am, appellant side also and respondent side also will represent both the sides together. I will address
So
issue
पहले
1,
appellant side.
she's going to address issue 2, and then third by me and fourth by her, and same goes with the respondent one.
No. The point which the ma'am is asking that you have how much time they have? Miss
15
Jyoti?
minutes.
So they
15
have
minutes.
15 minutes to present the case and 5 minutes for rebuttal and show rebuttals.
Rebuttal. So you will be presenting also and you will be presenting the rebuttal also.
Ma'am, this
Beta, who
is
will
what
speaker one,
we are
motor one from your side? Who
Who
will
is the
start
mooter
first?
one? Issue number one, please start. Don't get confused. Issue number one, start. Mooter one with issue number one, start. You must be from an appellant side. Issue number one, appellant side. आपने अपील डाली है मैम mooter number
Good
one.
afternoon, respected judges. Good afternoon, respected judges. Counsel on behalf of petitioner would like to request jury
Jury
to
system is
present the
abandoned.
statement of jurisdiction.
Jurisdiction, okay.
The petitioner humbly submits the jurisdiction of the Honorable Court under Article 134 of the Indian Constitution.
Okay.
Issue number 1. Whether Mr. Vicky can be held liable for the cyberbullying and harassment endured by the Aliza. We stand before this esteemed court on behalf of Mr. Vicky, the appellant in this case. Mr. Vicky is a 17-year-old student who is falsely accused of cyberbullying Miss Aliza. The lower courts convicted him based on the circumstantial evidence and statement gathered during the investigation under Article 161. This argument will demonstrate that Mr. Vicky is not liable for cyberbullying. We will address the prosecution's claim, highlighting the limitations of the evidence and emphasize the possibility of hacking incident compromising Mr. Vicky's account. The prosecution primarily relies on the traced IP address linking Mr. Vicky's device to the messages. While this might seem incriminating, it falls short of conclusive proof. Digital footprints can be easily manipulated in today's technological landscape. A compromised system or malicious third party could have used Mr. Vicky's IP address to send the messages. Not cyberbullying. Mr. Vicky has constantly maintained that his is supported by the findings of a tech expert, Mr. Vinny, who identified evidence on hacking attempts. The prosecution dismissed the hacking claim without a thorough investigation. The possibility of phishing attack or unauthorized access to Mr. Vicky's account needs serious consideration. Furthermore, the use of AI generated content, as mentioned by Vinny, suggests a more sophisticated cybercrime attempt beyond Mr. Vicky's capabilities. Beyond the IP address, lack of concrete evidence, the prosecution built its case on a shaky grounds. There is no direct evidence linking Mr. Vicky to the creation of transmission or explicit images. Miss Eliza claimed that the images contain detail only Mr. Vicky knew remain unsubtitled, and the technology expert testified that the perpetrator had granted Eliza's personal data from her social media interaction to concord the explicit content. If Mr. Vicky wanted or willing to take revenge or something as alleged by the complainant, he could have shared those images to the public thing or with Eliza didn't clarify. He had shared them publicly. Absence of direct evidence. The prosecution case heavily relies on the circumstantial evidence, which is not sufficient to establish the guilt beyond the reasonable doubt. The Supreme Court in Sharda versus State of Maharashtra held that the chain of evidence must be so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused. Presumption of innocence. The presumption of innocence is a fundamental principle of criminal jurisprudence. In Dharam Deo versus State of UP, the Supreme Court held that presumption of innocence is a human right. Unless the guilt of accused is proven beyond a reasonable doubt, he is presumed to be innocent. The principle applies on Mr. Vicky's case as well. Standard of proof. The standard of proof in criminal cases is beyond the reasonable doubt. In state of UP versus Anil Singh, the Supreme Court held that if two views are possible on evidence abduction, in this case, one pointing to the guilty of accused and the other to his innocence, the view which is favorable in the accused should be adopted. This principle is applicable to Mr. Vicky's case where there is no reasonable doubt about his guilt. Mr. Vicky, a minor, 17 years of age, with a clean record, has falsely accused with the offense of cyberbullying based on prima facie circumstantial evidence. This prosecution's case rests on weak foundation, a single traced IP address, expert testimony, and possibility of hacking incident offer a more possible explanation for the event, and statement of tech expert have been clearly ignored during the investigation. We urge Honorable Court to consider all the facts presented. Mr. Vicky himself is a victim of cybercrime and his privacy has also been violated during the investigation. Along with the council, seek deep concern about his age, that is 17 years. He is minor and was treated as an adult from day one to investigation. Hence, council proceed with Mr. Vicky not guilty for the charge of cyberbullying and harassment.
Okay.
Council seek to address the issue too.
Issue 2 you have already addressed, isn't it?
It was issue 1, sir.
Okay.
Hmm. But in your issue 1, you have made the submission that since the very first day of the case, the court has been considering him as an adult, not as a juvenile. You almost
It was
covered
an
your
additional
submission
point.
of issue 2.
Okay. Chalo, you covered
That's
the
okay.
issue 2 specifically.
It
You
was
covered the
the
issue 2.
हाँ,
conclusion point additional.
Okay. You covered the
हाँ.
issue.
Issue number 2.
Please proceed with the issue
Whether
2. Please.
क्या?
whether the age of
Pardon, ma'am. Pardon, ma'am. We
issue
haven't
number two.
listened. Could you explain?
You continue on issue number two.
Much obliged.
Issue number 2. Whether the age of Mr. Vicky warrants special consideration for him, and should he be regarded as a juvenile or as an adult in these legal proceedings. We represent Mr. Vicky, the 17-year-old appellant in this case. The lower courts disregarded his age and vulnerability as a minor while convicting him of cyberbullying. This argument emphasizes the importance of Mr. Vicky's age and urged the court to consider him under the purview of the Juvenile Justice Act 2015. As per Section 2 and Subsection 35 of the JJ Act, Mr. Vicky is a juvenile and should not be treated as an adult. Even as per Section 15 of the Act, a juvenile offender between the age of 16 to 18 years who has committed a heinous offense may be tried as an adult by putting him to trial under the criminal justice system. However, a juvenile offender can only be tried as an adult under the Act after the board, with the assistance of psychologists or psychosocial workers or other experts, has assessed the juvenile offender on the following. First, the capability of the juvenile to commit such type of heinous crime, his ability to comprehend the consequences of the offense committed, and the third, the circumstances in which the offense was committed. The board's responsibility is to recognize whether the offending child can commit a heinous offense and whether the offending child understands the consequences of the offense committed. The board must complete its assessment within 3 months
But
from the
Vicky
date of
was
the.
very well, sorry, but Vicky was well knew the consequences of his act. That is why he was not considered as the juvenile. And don't you think it's a heinous crime or it's a heinous offense?
Ma'am, it is indeed a heinous offense, but
So
as per
derogatory,
our
so Vicky, as in fact, as per doctor also, Vicky is a person or is a thoughtful person.
ma'am, but
So
as per doctor's
if a
statement only,
person
doctor
is a
testify
person of
himself that
sound mind, he's a person of
yes, even
sound
though
mind,
Vicky is a
and
person of sound. Yes.
he is a person of sound mind. He is having his own account. Even the IP address was same. Don't you think that he made the third party to involve in the matter?
Ma'am, we disagree with that because as if we go with the doctor's statement only, doctor himself testified that even though he is a person of sound mind, but he could not do anything wrong to Miss Eliza in his statement.
So that is
Along with
again a
that, if
presumption.
we talk about IP
Doctor's
address,
so doctor's opinion may be regarded as a presumption as well. A person of sound mind cannot do this. How
ma'am,
can you
doctor
take
is
this surety that?
because doctor is an expert counselor of this respected school.
But the court
So
is
we
not bound to take the expert opinion or the doctor opinion on record. That's a discretionary power of the court. We are not bound with that.
yes, ma'am, but we are relying on the statement and the facts we are
You
provided
are
with.
relying,
So
but we are
presuming
not
that
bound to rely on the opinions of the doctor's opinion or expert's
So,
opinion.
ma'am, what ma'am is actually indicating? Do you have anything else that she will? That is what she is indicating. So, do you have anything else to submit in support of your claim?
yes, sir. In that IP address we are talking about throughout the time, that IP address is basically the internet protocol, which is a name given to the internet. And here it can be manipulated easily in today's technology. IP address can be traced. There are many evidences
5 minutes left.
such as different. Pardon me, ma'am, I haven't listened. Vicky, Vicky's friend Karthik, he has also testified that his account was hacked, and even the tech expert Vinny, which was hired by the investigation officer himself, also testified that his account has been hacked, and there is some perpetrator who might have hacked his account, but Vicky haven't done anything. And moreover, sir, there is a board of this juvenile who go through this investigation once, that whether we should trial him as an adult or as a juvenile. But as we can see, only 14-day investigation was done, and from the day one, Vicky was treated as an adult. Throughout the memorial proposition, we haven't seen name of juvenile court, children court,
So
and
your
the
argument is that Juvenile Justice Board has not examined the wiki before declaring it adult. This is what you want to summarize?
sir.
Okay.
Along with this, we want to argue this also, that from the very first day he was treated as an adult, and as per our JJ Act, children before 18 years initially should be treated as juvenile, even though later on court can recommend them to treat as adult, but initial stages he is a juvenile. There should be
Okay.
proper board, there should be consideration. It might all affect his mental health and emotional well-being, also his well-being around school and reputation, future. Everything depends if a person get into some criminal trial and the name tag of.
Okay, point taken. Next point. Next issue.
Issue number 3, whether penalty post Mr. Vicky is justified and legitimate. 10-year sentence appeared predetermined and fails to consider the nature of alleged crime. While cyberbullying is a serious issue, a 70 severity can vary depending on the content, intent, and lasting impact. The punishment is not justified, as Mr. Vicky is a 17-year-old minor who was investigated as an adult, treated as an adult, and sentenced 10 years of imprisonment for cybercrime, which is indeed a serious offense, but not all cybercrimes are heinous. Each case has been a different gravity of crime and depends on different circumstances. Considering Mr. Vicky's age and potential for reforms, Mr. Vicky's age is a critical factor. At 17, his thought process and emotional response are still underdeveloped. Principles of Dolly in Capex. The principles of Dolly in Capex, recognized in Pratap Singh versus State of Jharkhand, holds that a child under the certain age is incapable of committing a crime as they do not possess the mental maturity to understand the nature and consequences of their action. This principle is applicable to Mr. Vicky's case. In the case of Shilpa Mitra versus State of NCT Delhi at 9th January 2020, the Honorable Supreme Court held that this act does not deal with the fourth category of the offence, which is punishable by more than 7 years, but does not consist of minimum imprisonment or minimum imprisonment of fewer than 7 years. Hence, this is known as serious. This is not known as serious offence in this context. The court has also directed the High Court to take children's name out of the child in conflict with law. Therefore, the matter was disposed.
Okay.
Disappropriate.
Okay, move on to next point.
To the next issue.
Yeah, issue number 4.
Whether Vicky's fundamental right of privacy has been breached in the investigation as his system was looked into without his permission and knowledge. Whether the investigation should be set aside on their forfeit ground. The right to privacy is recognized as a fundamental right under Article 14, 19, and 21 of the Indian Constitution. In Justice K.S. Puttaswamy versus Union of India, the Honorable Supreme Court has held that privacy is an intrinsic part of the right to life and personal liberty. The
Okay,
Constitution
point
of India.
taken in that judgment. Next. Any other citation for this?
Citation, this case no.
For this right to privacy?
For issue number
In
4.
in MP Sharma versus Satish Chandra,
The Supreme Court has held that forcible extraction of information from the accused, which is likely to incriminate him, is barred under Article 23 of the 3 of the Indian Constitution. The unauthorized access to Mr. Vicky's computer system can be seen as a violation of this protection.
Okay. Even if the offense is cognizable, then also the access is unauthorized?
Sir is asking even if it is the cognizable offense, then also it is unauthorized. Sir, it violates the fundamental right to privacy. So it is.
Okay,
But there
continue.
are some cases where
Continue.
Sir, time is over actually. So it is up to the discretion of you.
Just let them finish this point.
Wind up quickly. Highlight the main points only.
in light of the issues raised, advanced, and authorities cited, it is most respectfully prayed that this honorable court may be pleased to adjudge and declare that Mr. Vicky is not guilty of the charge of cyberbullying and harassment, considering the circumstantial evidence, expert testimonies, and the possibility of a hacking incident. Second, acknowledge that Mr. Vicky, being a minor of 17 years of age, should be treated as a juvenile offender under the provision of JJ Act, ensuring a more human and effective approach to justice. Order a retrial with due process followed, including procedure that considers the specific vulnerability of a minor. The court may also be placed to pass any other order which this honorable court may deem fit in the light of justice, equity, and good conscience. For this act of kindness, the petition shall duly bound further.
Good, good,
Good job, guys.
good job, good job. Thank you.
Which year? Which year? Which year?
Which year student?
Fourth, third year student, ma'am.
Third year student.
Third
Myself,
and
third
fourth.
year student, fourth year.
So
Mooter
one is
one
fourth
is
year, one is third year.
हाँ.
Yes.
Sir, Mooter one is third year student. Mooter two is fourth year student.
Good, 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 good.
Thank you.
Good. Good. All the best, guys.
Thank
We'll
you.
intimate you, beta, for the next proceeding. We will intimate you.
Thank you.
Thank you.
Beta, we will intimate you for further proceedings.
Hmm.
Now, sir,
Are we done with the job or रह रहा है मैम कुछ?
एक
18
team रह
minutes.
गई है, ma'am.
हाँ.
Only one team left. A5.
अब बुला लो just after 2 minutes ना बुला लो just after 2 minutes.
Okay, okay, sir. No issues.
2 minutes.
Team A5, you can turn on your cameras, beta.
Good afternoon, ma'am.
Good afternoon,
Very
ma'am.
good afternoon, beta. Beta, you have only 15 minutes to present your case. Got it?
Yes,
And
ma'am.
it is up to the discretion of the judges. They can ask any questions as the judges are asking questions from the teams. Got it?
Okay. Yes, ma'am.
Only 2 minutes. We will start the proceedings.
No problem.
Team B1, why you have joined, beta? Team B1. Team B1, please exit the link. Team A5.
Yes, ma'am.
Beta, are you there in the inaugural session?
Yes,
Yes,
ma'am. We
ma'am.
were there.
Nice.
Okay, where the team has joined.
Yes, our team has joined.
Good afternoon, sir.
Good afternoon. Good afternoon. Okay, start your moot. Start your mooting.
Yes, sir. Greetings to the Honorable Court. So this is Anmol Sharma, Council 1, with my co-councillor Navjot and our researcher Brian. So today we'll be dealing with petitioner side. So with the due permission of the court, the council seeks permission to start with the proceedings. Much obliged. The council seeks permission to address the Honorable Court as your lordships. Much
As per
obliged,
your
your
desire.
lordships. The council seeks permission to state the statement of jurisdiction.
Okay.
Much obliged. The petitioner has approached the Honorable Supreme Court of India under Article 132 and Article 136 of Constitution. If your lordships are agree with the statement of jurisdiction, the council seeks permission to move further with statement of facts.
Yeah, continue.
The council seeks the permission to present the statement of fact before the Honorable Court.
Please.
Continue.
Much obliged, Lordship.
Hmm.
Miss Eliza, a 19-year-old student and a school prefect at Howard High School, received explicit and malicious images of herself on January 14 via her social media account on Hacker. The police investigation traced the origin of the images to a device belonging to Mr. Vicky, a 17-year-old student at the same school and a former friend of Eliza. Eliza and Vicky's friendship deteriorated after a heated argument between an offer for Eliza to study abroad. Vicky denied the involvement in the cyberbullying incident and claimed that his social media accounts were hacked. Witness described Vicky as having a short temper, but he insisted he
Facts,
would.
facts are already there. They have been examined by two courts. You come to your issues and your arguments in support of your claims.
Yes, sir. So the council number 1 will be dealing with issue number 1 and issue number 4, whereas the
Yeah.
council number 2 will be dealing with issue number 2 and 3. So with due permission of the court, the council seeks permission to start with issue number 1.
Yes, yes,
With your
yes.
your lordship. So issue
Yes.
number 1 states whether Mr. Vicky can be held liable in the cyberbullying and harassment endured by Eliza. So
Yes.
your lordship, in the matter before this honorable court, the petitioner Mr. Vicky asserts his innocence and allegations of cyberbullying and harassment leveled against him by the respondent Miss Eliza. The prosecution has failed to produce conclusive evidence linking Mr. Vicky to the cyberbullying incident. The prosecution has not established a clear causal link between Mr. Vicky and the cyberbullying endured by Miss Eliza. Mere association with the victim or prior disagreement does not amount to conclusive evidence of guilt, especially in the absence of direct involvement or motive. The prosecution's case relies heavily on the speculation.
How do you counter the source of this cyberbullying? Source of the cyberbullying is the system owned by Mr. Vicky. How do you counter that?
Sir, can you please repeat?
You said there is no relationship, then there is no direct relationship. How do you counter the fact that the IP address is of Wiki only, the system through which this all bullying was done is of Wiki only?
Yes, sir. Yes, sir. It was stated by Mr. Vicky that his system got hacked, and due to the system got hacked, there is no direct relationship. There is no direct proof that can be presented before the court by the respondent side Eliza that can prove the guilt of Mr. Vicky, that Vicky was directly involved in the cyberbullying and harassment done to Miss Eliza.
And it can be also taken from the fact that Miss
But
Winnie,
the
who
IP
is the tech
address was
expert,
same. If you say that there is no direct link between Vicky and Eliza because the account of the Vicky was hacked, but the IP address was same. IP
Ma'am,
address
yes.
belongs to Vicky only.
Ma'am, as we can take from
Once
the
we
fact that
see that the IP address is same, then it can be say that there is a direct relationship between Vicky and Eliza for harassing the girl.
Ma'am, the council want to state here that we can take the if we see or go through into the fact, we can see that Miss Winnie, who is the tech expert, she has already confirmed that his account, that Mr. Vicky's account, has been hacked, and his PC was compromised and hence from where we can say that he was not directly involved there. And also, when his friend Mr. Kartike was examined, he also has given the statement to the Inspector Sharma that yes, he has also received the messages from Mr. Vicky's account, which were not actually sent by Vicky. So if we can say that if the messages were not sent by the Wiki to Kartikeya, similarly, there could be the possibility that the images were also not sent by the Wiki to Eliza. And also Miss Winnie has also stated that Eliza has confirmed the fact that there was some information which has been taken from her account only.
And
Okay.
ma'am, the presence of malware and hacking attempts on the accounts of Mr. Vicky, it is confirmed by the expert testimony, that's Ms. Winnie, that casts about the integrity of the evidence against him. So Miss Eliza's motive in implicating Mr. Vicky must be scrutinized, particularly in the light of their prior disagreement and strained relationship. The prosecution's case hinges upon the assumption that Mr. Vicky's guilt while overlooking potential alternative suspects or motives for the cyberbullying incident, and Mr. Vicky is entitled to the presumption of innocence until proven guilty beyond a reasonable doubt.
Okay. Okay, fine. Concluded. So you can move on the next point.
Sure, sir.
Issue 2.
So, in conclusion, the council would like to state that in the present case, Vicky has been convicted for the cyberbullying and harassment endured by Miss Eliza beyond a reasonable doubt, and the absence of direct evidence coupled with the violation of Mr. Vicky's privacy rights during the investigation undermines the integrity of the case against him, and therefore any conviction based on such flawed evidence would be unjust and contrary to the principles of justice. If your lordship are satisfied with issue number 1, the council seeks permission to move with issue number 2.
Please
Much
continue.
obliged, your
Yes,
lordship.
please.
You know,
Please.
The council seeks the permission to address the second issue before the Honorable Court.
Yes.
Much obliged, Lordship. So, the second issue states whether the age of Mr. Vicky warrants a special consideration for him, and should he be regarded as a juvenile or adult in these legal proceedings. So, it is humbly submitted that Mr. Vicky's age merits a special consideration, compelling a court to treat him as a juvenile as delineated below. So, my first contention is the definition of the child under the Act. The Juvenile Justice Act of 2015, in its section 2, clause 12, defines a child as an individual who has not yet attained the age of 18 years. Correspondingly, section 2, clause 35 gives that the juvenile encompasses those below 18 years. And along with that, in the legal stance, aligns with the United Nations Convention on the Rights of the Child, which under Article 1 recognizes the individual under 18 years as a children. So my next contention includes the imperative of the preliminary assessment. It is respectfully contended that Section 15 of the Juvenile Justice Act places a pivotal obligation on the court to conduct a preliminary assessment. This assessment is essential to evaluate the mental and the physical capacity of the child to understand the consequences
But he
of
was
the
considered
alleged.
as an adult since the sorry. But he was considered as an adult since the very first day of the proceeding because of the gravity of the offence which he has committed. For the
Ma'am,
heinous offence which has been committed, and moreover, it is clearly mentioned here that he very well knew the consequences of his acts, and he
ma'am,
has a thoughtful mind, as the doctor also said that he is a person of a thoughtful mind.
ma'am, for this, I would like to
That
draw
is
your
why it was
attention.
considered as
sorry,
an
ma'am.
adult since the very first day of the proceeding.
May I, ma'am?
Yeah, please.
Yes, thank you, much obliged, Lordship. So I would like to draw your attention towards the guidelines which were given by the Apex Court in the case of Varun Chandra Thakur versus Master Bholu and another, in which the accused, who was aged over 16 and stood accused of the grave offense of murdering a class 2nd student by slitting his throat in the bathroom. The Apex Court deliberated on pivotal issue surrendering Section 15 of the Juvenile Justice Act 2015, which allow the board to solicit the assistance from a seasoned psychologist or a other expert in assessing a child's mental and physical capacity to commit the offense. Moreover, it addresses their ability to comprehend the ramification of their action and contextual circumstances. Furthermore, the court underscored that their mere demonstration of the mental capacity, as indicated by an average IQ level or IQ score, falls short in gauging an individual's comprehension on the offense's consequence. The court emphasized that the imperative of assessing these consequences comprehensively, considering not only the immediate impact but also the far reaching implication for the victim, the accused child, their family, and the society at large. The court has interpreted the term may that in within the scope of Section 15 of Juvenile Justice Act, it is deemed that it is obligatory for the board to seek the external expertise when lacking a professional with credential in the child psychology or psychiatry. So here in this case, Mr. Vicky was solely Mr. Vicky was tried as an adult without undergoing any type of assessment. The court relied only on the basis of the Vicky's age without delving into the broader examination of his comprehension of the offense consequences. So this oversights that this regards the fundamental principle enshrined in this law, demanding the fair evaluation and the due process for Mr. Vicky.
Okay. Please move to the next issue, sir. Sir, to issue number 3, they are moving to the issue number 3.
4 minutes are left now.
If the court is satisfied with this
Around
application,
4 minutes.
the council seeks the permission of the Honorable Court to address the third issue.
Yes, yes, please.
The third issue states whether the penalty imposed on Mr. Vicky is justified and legitimate. It is humbly submitted that the penalty imposed on Mr. Vicky is not justified or legitimate. While the severity of the cyberbullying cannot be understated, the evidence presented during the proceeding does not conclusively establish Mr. Vicky as a perpetrator. The plaintiff's assertion of hacking and the lack of the direct evidence linking the Mr. Vicky to the creation and dissemination and of the malicious content raises a reasonable doubt regarding his culpability. From the fact itself, it could be seen that Mr. Vicky was still the well-wisher who was concerned for Eliza. Moreover, Vicky was very thoughtful, and he was thoughtful enough that he said he would never do something of this sort to anyone. Also, from the statement of Sania, who was the friend of Eliza, which the statement she has provided to Inspector Sharma, where she stated that Miss Eliza may have staged the quarrel as she did such activities at other instances also. Proceeding further towards, I would like to draw the attention of the court towards the Dr. Anish statement. Dr. Anish has also stated that Vicky was very calm even after the quarrel and had decided to apply to the other places for the studies in abroad. Meanwhile, the statement of Dr. Anish was different for Eliza, that she was very bitter about the quarrel. Along with that, if we take the statement of Miss Winnie, the tech expert, that she, after the analysis, has also confirmed that the phishing attacks were done over the Wiki's PC and has also confirmed that Wiki's PC was compromised. So from here, we can say that we can establish that there was no intention of the Wiki to harass Miss Eliza in any form. Post on Wiki is just unjustified and legitimate through the statement of the minister while introducing the bill, which he has given while introducing the bill in the parliament, that the substantial reliance from the legislative intent behind the enactment of Juvenile Justice Act, the minister during the introduction of the bill expressly indicated that offences such as murder, rape, terrorism are those that ought to be categorized as heinous offences under the Act. Also, in case of Shilpa Mittal versus State of Delhi, the apex court deliberated the cases involving the juveniles aged between 16 to 18. The court opinioned that offences falling into the category where the maximum sentence exceeds 7 years but no minimum sentence is proved,
or where the minimum sentence is less than 7 shall be treated as serious offense under the act, and the child should be uh, and the preliminary assessment shall be done to confirm whether the child should be treated as a juvenile or an adult. So, in the light of foregoing, it is evident that the punishment meted out exceeds the bound delineated by the legislative framework and the principle enshrined in the Juvenile Justice Act of 2015.
If your lordship are satisfied with issue number 3, the council seeks permission to move further with issue number 4.
Yes, yes, continue.
By your lordship. So issue number 4 states whether Vicky's fundamental right of privacy has been breached in the investigations as the system was looked into without his permission and knowledge, and whether the investigation should be set aside a forced ground. So, Lordship, the Article 21 of the Indian Constitution guarantees the right to privacy as a fundamental right, and intrusion into an individual's personal space, including the unauthorized access to their electronic devices, constitutes a breach of this constitutional safeguard. The investigation into Mr. Vicky's alleged involvement in cyberbullying and including accessing his personal computer system without his permission or knowledge. So this violates his fundamental right to privacy as enshrined in the Indian Constitution. The exclusionary rules prohibits the admission of evidence obtained through illegal means. As per Section 24 of the Indian Evidence Act, evidence obtained through coercion, inducement, or violation of the privacy rights is inadmissible in court. Any evidence derived from the unauthorized access to Mr. Vicky's computer system should be deemed inadmissible under this rule. Article 21 guarantees the right to fair investigation and trial. This encompasses the right to be informed of the charges, the right to legal representation, and the right to confront witness and their evidence against oneself. The unauthorized intrusion into Mr. Vicky's personal computer system deprived himself in the procedural safeguards, undermining the fairness of investigation and potentially tainting the trial proceedings. Your Lordship, in the landmark case of Justice K.S. Puttaswamy versus Union of India, the Supreme Court affirmed the right to privacy as a fundamental right under Article 21 of the Constitution. The court emphasized the importance of protecting individuals from unwarranted intrusion into their personal affairs, including their electronic devices. Moving further with the case of State of Punjab versus Baldev Singh, the Supreme Court reiterated the principle that evidence obtained in the violation of fundamental rights should be excluded from trial proceedings. In this case, evidence obtained through illegal searches was deemed inadmissible, emphasizing the importance of upholding constitutional safeguards even in the context of criminal investigations. Moving further with the case of Khadak Singh versus State of UP, in the case Supreme Court recognized the right to privacy as inherent in the fundamental rights guaranteed by the Indian Constitution. The court held that the unauthorized surveillance of an individual's movements and activities violates their privacy rights under Article 21. So the investigation into Mr. Vicky's alleged involvement in cyberbullying involved a blatant violation of his fundamental right to privacy. The unauthorized access to his personal computer system not only breached his constitutional safeguards but also compromised the fairness of investigation and potential trial proceedings. Therefore, the investigation should be set aside on the grounds of this egregious breach of privacy rights. If your lordship is satisfied with issue number 4, the council seeks permission to move further with the prayer.
Yes, please.
Much obliged, your lordship. Wherefore, in the light of issues raised, arguments advanced, authority is cited, it is humbly prayed before this honorable court may be pleased to adjudge, hold, and declare that Mr. Vicky cannot be held liable for cyberbullying and harassment endured by Miss Eliza. Mr. Vicky's age should indeed warrant special consideration in the legal proceedings, that the penalty imposed on Mr. Vicky is not justified or legitimate, and Mr. Vicky's fundamental right to privacy was indeed breached during the investigation as the system was assessed without his permission or knowledge. And the petitioner additionally prays the Honorable Court may pass any order as it deems fit in the interest of justice, equity, and conscience, and for this the petitioner shall duty bound every pray, respectfully submitted by the counsels for the petitioner. Much obliged, Your Lordship.
Thank you. Good show.
Much obliged, sir.
Good job.
Thank you, ma'am.
All the
You
best.
can
sir.
log out.
Thank you, ma'am.
Jyoti.
Yes,
ये
sir.
ये सारे लॉग्ड आउट हैं, कैंडिडेट सारे
Yes,
लॉग्ड आउट
sir.
हैं.
सर लॉग आउट है ना सर? एक सेकंड सर. Yes, sir. Now all are log out. We all three here.
हाँ मैडम बताइए कौन है, who are the teams who should go next round?
Who you want to see the next round? Jyoti ma'am, to whom you want to see in the next round? The team.
Ma'am, sir, only 1 second. I think our program is on the YouTube. Just 2 minutes. Give me a 2 minutes only.
Okay, 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 okay.
So students are really doing very well.
हाँ नहीं बहुत अच्छा किया, बस एक ही इशू था कि सारे बचाने वाले थे, फंसाने वाली एक ही टीम थी बस।
वो जो आई थिंक B2 आई थी जो
हाँ नहीं B1
स्पीकर
B1
B1 में, हाँ B2 में तो there were 2 girls.
Sir,
B1 where
ma'am,
there were
it's a please. Sorry to interrupt you.
Yes,
Actually,
yes,
this
yes.
is a YouTube program, so we will connect on the call. At present, we can leave the link.
So we are leaving the link. Okay.
we are
म्यूट कर दो सर, म्यूट कर देते हैं हम और कॉल करते हैं। मैं आपको कॉल करती हूँ, तीनों कॉल पे रहते हैं।
करना चाहिए, यहाँ से लीव हो जाए।
लीव नहीं होना, एक बार म्यूट कर देते हैं यहाँ पे।
अच्छा
म्यूट
कर
कर, ओके।